Why is this jury out 2.5 hours? What is going on here? Let's bring in our think tank. Joining us tonight, criminal defense attorneys Molly Palmer, Michael Sterling, former federal prosecutor also, and Holly Waltman. Welcome to you all. Michael Sterling, let me begin with you. Did you just see the video I saw?
I did, Vinnie. It's very disturbing.
Okay, disturbing. Is it compelling?
It's absolutely compelling.
Does it tell the whole story?
I believe it does. I believe it does. Now, I will say that, you never know what someone's mental state is. A video can't give you someone's mental state, whether somebody was involuntarily intoxicated or other potential defenses, but that doesn't seem to be the case here.
How about this? Passion, provocation. They're admitting that he shot and killed her, but they're saying that he sort of snapped. You know, it's almost like, Holly, like when a man comes home after a long day at work and he opens up the door and he sees his wife engaging in something with the cable guy on the couch, and he snaps and he grabs his gun and he shoots him. And we say, no, it's not first-degree murder. This is heat of passion killing. That's what they're alleging, Holly.
Absolutely. And Vinnie, I think we have a lot of the hallmark characteristics of a case that could have that be viable evidence for the jury. We have a recent divorce of a long-term marriage coupled with a funeral.
Wait. You're not going to justify murders because of divorce. I mean, the divorce rate is 50% in this country. Molly, is it 50%?
Maybe more or less 50%, but it's
Okay.
not just divorce. His son had committed suicide. He was under incredible stress from the entire situation. We have a 2-hour confrontation in a parking lot. We don't know what led exactly to that moment where he snapped.
Oh, wait. We don't know what happened, Holly. Passion provocation requires what? Provocation. So where is the evidence of provocation in this case? As I recall, the defense offered none.
Well, Vinnie, the jury clock is still ticking, so clearly they are talking about something. And if the state put forward a clear case where there was no provocation, then they wouldn't still be out talking about it.
All right, Michael Sterling, when we talk about passion provocation, heat of passion killing, it's got to be almost, and there's another way to call it, like irresistible impulse. I remember that from law school too, and from my days as a prosecutor. I mean, if they're having an argument, he's angry with his wife or his ex-wife. I mean, that's pretty normal stuff.
Yeah, I mean, I think, Vinnie, the video shows him running her down and shooting her from behind. If somebody's running away from you, it's going to be, I think that makes it a lot harder to demonstrate some sort of heat of the moment or passion or provocation, because it's not like they're in some intense face-to-face confrontation, but rather she's trying to escape. A good Samaritan's trying to help her, and he runs her down and shoots her in cold blood.
Yeah, Holly, I have a real problem, because you got the Good Samaritan coming in, intervening. As a matter of fact, the first few times he tries to fire the gun, it doesn't work.
That's true, Vinnie, but again, we don't know, and we aren't privy to the conversation that was happening between the two of them, the 2 hours right before this. We also can't really put ourselves in the state of mind that he was in, having just buried his young son who had committed suicide.
Right, but she just buried her son too.
Absolutely, and it goes both ways. We don't know what she said. We don't know if she had threatened him or what she had promised to do, maybe take the other kids during the course of the divorce. We just don't know, and I believe
wait, this is all normal stuff you're talking about.
That's
Passion
not normal.
provocation is like, oh my goodness, like you could almost rationalize it in some strange way. But there are 50% of the population getting divorced. I mean, I've got friends that, unfortunately for them, do this kind of work.
Sure.
And I mean, you wait around the holidays, they're always fighting about kids, and I'm going to take the kids, and I'm going to do this, and I'm going to do that.
But what portion of those 50% of failed marriages that end up in divorce, coupled with 3 months or less time passing and burying a minor child who had committed suicide? That is not a large number of people or individuals. This is not a normal routine or even half the time situation.
Molly, how much time does it take to, like, all right, because he didn't come to the argument with the gun, he has to, like, get the gun, right? Doesn't that take a little bit of time of reflection, a little time to plan what you're going to do? Because I'm going to get the gun because I'm going to use the gun.
I mean, that's the question for the jury right now. Was this premeditated? You can think about it is this in cold blood a thoughtful killing? Or is this just spur of the moment, losing your mind, heat and passion, and just a momentary lapse of reason that results in the death of another? And that is exactly the question for the jury. How much time are they going to consider when it comes to premeditation and forethought? Was this a murder with forethought or not?
All right, we've covered the law. Let's talk about the reality and the emotion of this case, because that came from Bethany Wellman. This is the victim's and the defendant's daughter who testified for prosecutors today.
What do you do next?
I frantically got dressed because we just went swimming. I ran to the elevator and went to my sibling's room. And I was begging and pleading that someone would open the door. My little brother opened the door, and I asked him if Mom was in the room, and he said she wasn't. And he's like, "Do you know where she is?" And I said, "Oh, it's okay, bud. I'm sure she's outside smoking." I ran to the elevator again, and kind of the same thing, wishing it would open faster. And I ran from the entrance of Days Inn and took the long way. And sorry, I found my mom laying there on the ground. I'm sorry.
Bethany, don't apologize for how you feel and how difficult this is for you. Do you need a moment?
I'm okay.
So at that point, when you come out and you indicated you kind of had to go the long way around the hotel, is that because you kind of came out the wrong door and you...
At that moment in time, I didn't even know where the other door was. I just knew I needed to run and get outside as fast as I could.
Ultimately, when you come upon your mom, what, if anything, or who, if anyone, did you see?
I just remember a detective or someone was standing there. I couldn't get close. I fell in the process of running to get to her, and I remember ACAD pulling up and them trying to perform CPR and failing ultimately on her.
Incredible courage from Bethany Wellman, who is the daughter of the victim and the defendant. And Michael Sterling, during her testimony, she referred to her father as the defendant. How powerful is that?
It's very, very powerful. I can't imagine what that poor young woman is going through, Vinny, having lost her brother in a suicide and now having to stand as a witness in the trial of her father and the murder of her mother. But I think that was extremely powerful testimony that's going to sit in those jurors' minds as they sit back there and deliberate. That was some powerful, powerful testimony and real, just tremendous heartbreak by the daughter of the victim.
Yeah, Holly, I think it was pretty clear to the jury, through these subtle little things like calling your father the defendant, what she feels about him and how she feels about this case.
Absolutely. And Vinnie, one of the things I like to look at and take in, and I really think that juries take note of, is a witnesses' nonverbal testimony, their lack of reaction or the reaction, and their physical nonverbal clues. And she was absolutely compelling, and I don't think that anyone's heart can't break for that poor young lady who's going to have horrible tragedy following her for the rest of her life.
Molly, to me, you know, when the children testify, I don't know how many cases I have covered, whether they're adult children, young children, Harvard-educated children, or aerobic instructors. It doesn't matter. For the most part, I would say 19 times out of 20, children believe in the parent who's on trial. That's not the case here.
No, and I noticed immediately her referring to her father as the defendant, and that does speak volumes to the jury. Her testimony was incredibly compelling. It's just tragic. She's lost her brother, her mother, and her father is going to jail. The question is basically, I think, how long? And it's just tragedy, begetting tragedy, begetting tragedy.
All right, folks, we got a lot to talk about here. We're getting word that there's something happening in the courtroom. This could be a verdict. Do we want to take a break and come back? Is that what we're doing here, folks? Is that what we're doing? Let me know. Are we taking a break? We're going to take a break. There's some action in the courtroom. I can see it out of the corner of my eyes. We'll be right back, folks.
Ladies and gentlemen, the evidence will show you that they argued heatedly right there by her car for almost 2 hours. He didn't pull in and get a gun and shoot her. They argued loudly and vociferously for 2 hours, an hour and 50 minutes to be precise.
All right, folks, we got big breaking news tonight. A verdict has been reached. 2 hours and 39 minutes of deliberations, and the jury sent out a note saying they've reached a verdict. The judge is about to take the bench. I can see the defendant is in court seated, so they will be ready to go. They probably just need to get the lawyers in place and the jury set in the box, but there he is. I mean, can you imagine this? In one day, all the arguments, all the evidence, and a verdict in a murder trial that will determine the rest of your life. Whether or not you spend the rest of your life in prison or perhaps have some chance of getting out someday. But it just took one day. The defense presented absolutely no evidence. Everyone is standing. Usually that means either the judge or the jury is entering the courtroom at this moment. I don't hear any sound coming from the courtroom, so the judge must not yet be on the bench. But there you see the defendant with his attorney inside the courtroom. 2 hours, 39 minutes in a one-day trial. So the deliberations were a little bit longer, perhaps, than some people like me would have expected. But the choices here are clear. It's either first-degree murder, second-degree murder, voluntary manslaughter, or not guilty. Those are the choices for this jury. Let's listen in. All right, we're just waiting for the audio to be turned on inside the courtroom, but the judge is on the bench.
Reached its verdicts. Would the foreperson please hand the verdict forms and original instructions to the bailiff for delivery to the court? Would the defendant please stand while the court publishes the verdicts? As to count one, we, the jury, find the defendant, Danny C. Welte, guilty of murder in the second degree as submitted in instruction number 7. Signed by the foreperson. As to count two, we, the jury, find the defendant, Danny C. Welte, guilty of armed criminal action as submitted in instruction number 10. May be seated. Does the either party wish to have the jury polled? No, Your Honor. All right. Ladies and gentlemen of the jury, your work here is concluded, and I again want to thank you for your service in this case on behalf of the court, the parties, the community. I know this has been a difficult case. I'm sure it has been for the jury. I've watched you work. You've been very attentive. You've been focused. You obviously took your oath of responsibility very seriously, and so we do appreciate that. And that, of course, that's what we expect you to do, but you fulfill that responsibility. Ladies and gentlemen, I'm going to excuse you here momentarily, but I'm going to remind you what I told our alternates before they were excused, and that is there's nothing that prohibits you from talking with anyone you wish to about your service, including what went on back in the jury room. There's also nothing that requires that. That's your personal choice. If you're comfortable in doing that, that's fine. If you prefer this to remain a private matter, that's fine as well. So with that, ladies and gentlemen, if I'm going to excuse you, if you'll retrieve your personal items, your cell phones from the bailiff, turn in your number badges, and you are excused this time with the thanks of the court. Just leave your notepads there in your chairs. The verdicts are accepted by the court. The defendant is granted an additional 10 days to file post-trial motions as provided by rule. And at some point, we'll need to schedule hearing on those motions. Defendant, the court will remand the defendant to the custody of the sheriff for until the hearing on post-trial motions and sentencing hearing if necessary. Counsel, anything else for the court at this time?
No, Your Honor.
All right. The court will stand adjourned.
Danny Welte inside the courtroom, a one-day murder trial, escapes the top charge of first degree. There you see his daughter, who's really the daughter of the victim in this case. She seemingly disowned her father during the course of this trial, referring to him as the defendant. Obviously some sense of relief that they didn't come back not guilty or didn't come back with voluntary manslaughter. But second-degree murder in the state of Missouri carries a sentence of 10 to 30 years. So it appears the judge will have much discretion in the sentencing of the defendant, Danny Welte. Julie Grant from CourtTV Live, staying late tonight, joins us from the CourtTV newsroom tonight. Julie, first, your reaction to a guilty verdict, not for first degree, but for murder in the second degree.
Vinnie, I'm surprised. This looked to me like it was a first-degree murder case, and I'll tell you why. The difference between first-degree murder and second-degree murder in the state of Missouri is that premeditation factor, which you know, and we know that can be committed in an instant. Someone can premeditate or deliberate before causing the death of another person, so that's the big difference. And here, to me, the facts showed that he had plenty of time to premeditate this. When that Good Samaritan intervened and pulled him off of Echo Welte, when he was leaning in the car, when she was in the driver's seat of the car, and he pulled him away from her and told him to leave, and he did. That was time to cool off and stop this. But no, what did he do? He clears his gun 4 times. We know 4 unspent rounds were found on the ground and 1 spent casing, meaning there were 4 times there he could have stopped what he was doing. He was thinking about it. To me, I think all the facts go to premeditation. The fact that he ran across that parking lot to gun her down and shoot her in the back of the head when she never saw that coming. I don't understand how the jury got here. To me, Vinnie, I think this seems like a compromised verdict, and they split the baby, so to speak. The defense was asking for manslaughter, the state for first-degree murder. Do you agree?
I think so as well, especially in a case where, look at this, he almost looks happy now.
Right.
This is amazing, because this is a guy who looked lost throughout the course of this entire trial. And when I say entire trial, I mean today. It was a 1-day trial. But at this point, there was an incredible sense of relief and seemingly happy thoughts coming from this defendant. And I guess you're looking at, 10 to 30 is statutorily what the law says in Missouri, and maybe his attorneys have said, you're going to get out someday.
Mm-hmm. Oh, I think that's most certainly what he's thinking. And for them, this was just a matter of
Look at
penalty.
that, another handshake.
Right. They were going for the voluntary, which is 5 to 15. You know that, Vinnie. And as you mentioned before with this verdict announcement, 10 to 30 is now what he's looking at. Both a lot better than life. And really, the only time we saw him get emotional was when his own confession video was being played in court today. I thought he would get emotional when his daughter was up there on the stand. But no, not at all.
Do you think it strategically, and we talk about this in a lot of cases these days, why put in the confession video? You've got the video of the actual shooting and killing. Did they really need that? Because in a certain sense, that's what they wanted to hear again, and that may have been the defense case, even though it was put in by the prosecution.
You make such an excellent point, Vinnie, and the fact that they didn't get to hear it again because that was at the judge's discretion to allow them to rely on their notes and their memory for what they heard. We know this wasn't a case of whodunit. The defense was very smart to admit this was his action, totally caused by him, 100% by him, but they were disputing the way in which the homicide was committed without premeditation, according to them, and perhaps the confession was unnecessary. You make a great point.
Yeah.
Maybe it was just one too many
Julie,
pieces of evidence.
One other
they put
thing.
in.
Have you ever seen someone convicted of murder get a bottle of water after the verdict?
No, I usually see hands behind the back and handcuffs. This is shocking. I don't know why.
Casual situation in a court. It might be standard protocol there. Obviously, they have security, but this is so different, like you said, Julie, than other places, other jurisdictions where someone's convicted of murder. He's got a bottle of water.
Right.
And it looks like Fiji water.
Right.
That's not like
good water.
That's not tap water.
Right. It tastes good, been purified. Right. Fiji water.
And now he's speaking with family members. Is he speaking with supporters? He's been convicted of murder. Now he gets to talk to folks in the gallery?
Right. Has he been printed yet? I don't think he's been printed yet. I mean, he needs to be officially booked on this murder conviction now at the jail.
Wow.
So they should be taking his prints. That's what his hands should be doing.
Yeah, Julie, we've got other guests with us, Michael Sterling and Holly Waltman. I just want to bring them in. And maybe not from your case, maybe from your cases. Someone's convicted of murder. Does this look normal, Michael?
I've never seen anything like that, Vinny. Even when I've had lesser convictions of very, very minor offenses. Had a voter fraud conviction, and my client was immediately remanded into custody.
Wow.
I've never seen anything like that. Remanded into custody, handcuffed, taken to the back immediately. This is very, very unusual, but it may be standard protocol in that particular Missouri courtroom.
It may be. It's just different. Holly?
I think it's par for this trial. Everything about this has been a little unusual. The length of the trial, the fact that he was able to somehow not show any emotion during the testimony of his own daughter. It is very bizarre. I echo what Julie and Michael are saying. This is not common practice across many of the courts we practice in around the country.
Julie Grant, I haven't covered that through the years. I haven't covered that many cases out of Missouri, but I'm shocked. A one-day murder trial.
Right.
1 day.
Anywhere in the country, this is fast. This is really fast.
He's getting cuffed now. There you go.
There we have it.
After he had his water, of course.
And he's also cuffed in the front. That's still unusual.
Well, he's got to carry his designer water with him, Holly. Unbelievable. But he absolutely, Julie, tonight believes that he won this case.
Oh, 100%. I think for the defense, this is a win. You know, always argue for more than you really deserve, right? That's a motto for many attorneys. And I think they went in there arguing manslaughter at the beginning of this trial, saying this is a manslaughter case. And really, this was certainly at least second-degree murder, in my professional opinion, a first-degree murder case. I think there was plenty of time for him to form that premeditation to commit the act when he was being pulled off of Echo Welte, when he was told to walk away from her, and he did walk away, when his gun was jamming and he's clearing the gun, and we find 4 unspent rounds on the ground showing 4 times he could have stopped what he was doing. And when he made the decision to race across the parking lot and gun her down and shoot her in the back of the head when she never stood a chance, never would have seen that coming. And she was yelling before that he was trying to kill her. It's just truly a tragic case, and I think you're absolutely right, Vinnie. I think that the defense thinks this is a huge win, and it is a win for the defense side.
Yeah. Holly, Waltman, you agree? Because I'm absolutely agreeing with Julie right now.
I certainly agree. One of the things that I just noticed that I think is important to point out is neither side asked for the jury to be polled, where each individual juror has to come out and say, yes, that's my decision. I participated in the deliberations, and that's still my decision. And so to echo what you guys were just talking about, it almost seems like this may be something where they may consider not filing an appeal, because then they would just end up with potentially, best case scenario, a new trial with maybe a less sympathetic jury.
Michael Sterling, I think the defense looked extremely relieved and happy with the jury's decision. I mean, they came back and said your client's a murderer, but they were satisfied.
Yeah, for those of us who practice criminal defense law, you know that there are several ways to win a case. One of those ways is to get your client out of a sentence that they could spend the rest of their lives in jail. And here you had the possibility that this man was going to spend the rest of his life in jail. They were able to convince the jury that it wasn't premeditated and intentional. The jury still found that the murder was done without legal justification, which is the second-degree murder standard. And so for them, they get to walk out of court knowing that they were able to at least mitigate the punishment that their client was going to face, from life in prison to the maximum of 30 years. And in most jurisdictions, you serve 50% of your time on a violent offense and you're eligible for parole. So he's looking at potentially, being out at a maximum of potentially 15 years or so.
Yeah, Julie Grant, as I think about tonight, I'm thinking about Bethany, who testified today, who is the daughter of the victim. And, during the course of this trial, referred to her father as the defendant. So I don't think she considers him her father anymore. And tears from her in that front row during this verdict. And I'm wondering and I'm hoping that she's feeling okay tonight.
Right. So well said, Vinnie, well said. And I know it's heartfelt coming from you. That was heartbreaking today, watching her testify. It was truly heartbreaking. I can't think of a worse position to be in than she was on that day, when she just buried her brother and then finds her mother lying in that parking lot of that hotel with a gunshot wound to the head. And we know her mother didn't have a chance. She's shot in the back of the head, pronounced dead there at the scene, and she witnesses that. And so think about that, and then having to come into a court of law and describe what you witnessed and talk about your father and the argument he had with your mother and what you witnessed when you found your mother. It's truly just gut-wrenching, just thinking about what she went through. And we just certainly hope that that whole family finds peace. Hopefully they feel some sense of justice and some sense of closure with this verdict today.
All right, Holly, now you have to prepare for the sentencing, right? There's going to be some motions about the case, obviously, but the sentencing becomes a big deal. If you've got a range from 10 to 30 years, there's a huge difference between the top and the bottom of this range. What are your thoughts about what those arguments would be and how this judge is going to make this decision?
Well, I think certainly, and my hope is that the defense has saved a lot of their ammunition and preparation, knowing that this might have been an outcome that was likely to happen. And I hope they bring character evidence in on behalf of their client. Perhaps there's some mental illness records or some help that he might have sought in the months or years leading up to this tragic.
Do you mention the children at all?
You certainly mentioned the children, absolutely. Especially if you know that the state is going to ask that their daughter come back and and honor her mother with a victim impact statement. You certainly mentioned the children because she is going to be one of the children that comes and talks about the situation in their life, but my gut tells me that the younger ones may not. And so you plead to the judge's heart and sympathy that perhaps one day this terribly broken and fractured family could maybe perhaps come back and be rehabilitated and reunited.
Michael Sterling, how do you see the children playing out in the sentencing phase of all this, Michael? Is it an aggravating or mitigating factor in this case? I see it as an aggravating factor, that if you let this guy out early, he's going to be back out there and the kids are going to know that he's back out there.
Well, I certainly think that depends on the children themselves. As Holly mentioned, there are younger children who may want to have the hope of someday forgiving their father and letting him find some sort of redemption. And so for those younger children, depending on what they come to court and testify, what their impact statements are, they could be mitigating. It's very clear, though, with the older daughter who testified against her father in court and referred to him as a defendant, that the prosecution is probably going to have her back in an aggravating factor analysis to show that he deserves a very harsh sentence, something at the higher range, around the 30-year range. I'm assuming the prosecution is going to ask for the maximum penalty, which is the 30-year, because they believe that it was a first-degree murder. And I think they just need to watch Julie's statement tonight to understand how they should argue their case.
And Julie, when you look at this trial, the judge saw the video. The judge knows. The judge knows the impact. The judge knows a lot more than the jury knows, right? The judge knows everything about the case. And obviously, they make a record based on aggravating, mitigating factors, et cetera. But judges know the whole case and the whole story.
You are so right, Vinnie. And something else this judge may know is something the defense wanted to exclude, and those were complaints. Complaints made by Echo Welte while she was still alive, while she was preparing to file a petition for dissolution of her parents. We don't know a lot of details, but our CourtTV team always does that research prior to trial. And we know that she had lodged some allegations against him of physical abuse. So to me, I think the state can make a very clear case that this is a batterer. This is a domestic violence case. This is somebody exhibiting power and control over his victim. And when he lost control on that date, when his girlfriend broke up with him and his estranged wife didn't want him back, what did he do? He killed her. He murdered. That's what he did. So I think the judge, to your point, Vinnie, is going to know about what was excluded from this trial. What the jury didn't know about the allegations of physical abuse, this judge can know. And those prosecutors, I'm certain they are going to do their due diligence and bring out all of that at sentencing as aggravating factors.
All right. Julie Grant staying late with us tonight. Julie, we really appreciate your time, your insight. And please get some rest, because tomorrow I'm sure we're going to get much more information and reaction to this verdict tomorrow on Court TV. In the meantime, when we come back, it's the story that is blowing up all over social media as well as on our social media. The six-year-old who was zip-tied and arrested at school. Your reaction to that with our think tank when we return.
Seed extract for powerful antioxidant support, perfect for on-the-go energy. Act now, and we'll even include free shipping and free returns. That's over $30 in free gifts, all backed by our 90-day money-back guarantee.
So do something good for your heart, your circulation, your blood pressure, and your energy. You'll love Super Beets, or your money back.
Call 1-800-892-0615 or go to superbeetsdeal.com. That's 1-800-892-0615. Act now.
Okay, she's gonna have to come with us now.
Okay, Kai, you
Stand
gotta
up.
go with them, baby girl.
Stand up. Okay, come over here. What are those for? It's for you.
Keep your hands, okay? Come over here, honey. It's not gonna hurt.
No!
Okay,
No, I don't want handcuffs on! No! Don't put handcuffs on! Please! Help me! Help me! Please! Help me! Let's go.
Your grandma can come pick you up, okay?
Oh, I was in school. I just got you.
Come
on,
let's go.
No, please let me go.
Okay, come on. You can tell me what happened in the car, okay?
I don't want to go to the police car.
You don't want to?
No, please.
You have to.
No, please. Give me a second chance.
You gotta let
I don't want No. Please. 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 Please let me go. No. No, help me.
Okay.
Please. No.
Give me a second.
Appreciate it.
All right, yeah.
Call me if you need something.
Yep.
That's newly released video. That girl, 6 years old, a first grader. The backstory, yeah, she throws a temper tantrum. Yes, some staff members were struck by this 6-year-old, according to reports. But at the moment that she was taken into custody and put in the back of the police car, I think the tantrum was over. A 6-year-old is zip-tied with her hands behind her back. We just saw a convicted murderer get handcuffed in the front, and I'm watching a 6-year-old girl in first grade get zip-tied with her hands behind her. Are you kidding me? What is going on? Unreal. All right. That's my reaction. I've got your reaction on social media. And let me tell you, it's mixed. It's not necessarily the same as mine, but everyone's entitled to their opinions tonight. Our comment of the day, we begin with Ceedie, who says, she'll forever have issues with any person in a position of authority. This is traumatic. I don't care what a 6-year-old child does. This is definitely not the way to correct it. Think Tank is back with us. Molly Palmer, criminal defense attorney, your reaction to what you just saw.
I think it's reprehensible. And I think that viewer is correct in her comment. This does not correct behavior of a 6-year-old who's throwing a tantrum. And I have an issue as well with what you pointed out, Vinnie, in terms of the timing of this arrest. The child is sitting in a school administrator's office at this point, seemingly calm. And so to come in and arrest her, and you don't have this temporal connection to her quote-unquote offense versus this punishment, that makes this seem capricious to her. It doesn't make sense to her. She is 6 years old. This is not how you modify behavior, if there's even an argument that her behavior was deserving of some sort of modification to begin with. I think it's horrific to watch.
Yeah, the other part of the story is we don't know the background of this 6-year-old child. I mean, there are children that come to school that have all different things that they're dealing with, whether it's physical, mental conditions. I don't know the backstory yet. We're going to dig it up. We're going to dig up that backstory through the course of the rest of this week. Here's what Stephanie's writing tonight. Why didn't they just call the parents to pick her up? Michael Sterling, if I'm a parent, my child's acting out, I get it. Call me up, get me down there. I'll get the child out of there. You don't want the child back in the school to protect the staff and the other kids? I get it. But now you're zip tying my child, hands behind the back, and throwing her in the back of the police cruiser, and you're saying, oh, we can talk about what happened? How about, if you're going to put the zip tie, how about reading her rights?
Vinny, I tell you what, I've got a 6-year-old daughter who's in kindergarten. If a police officer had done that to my daughter, I would have needed to call Holly and Molly to represent me because I would have had a serious problem with what they did to my daughter. It makes absolutely no sense. That is not how you correct behavior. That is not how you deal with a 6-year-old child. You call their parents, let their parents come up to the school. If they have to pick them up for the day, you do something else. Arresting a 6-year-old child for throwing a temper tantrum is just an example of the over-policing of our society, where you have police officers getting involved over and over again in minor school disagreements or minor school issues where they have no business. We saw this happen a couple of weeks ago at Ball State, where a police officer got called to the classroom because a student didn't want to sit in his assigned seat. I mean, it is just the over-policing of society. And I have a problem with whoever called the police to report this in the first place. Why is the police department, who's there to protect and serve, who is supposed to be dealing with dangerous criminals, being called to an elementary school to deal with a classroom problem involving a 6-year-old child? It makes absolutely no sense to me.
Here's what Gordon's writing, and we're getting the other side of this. And there's always more than one side to a story, and I appreciate all of your reaction tonight. Gordon writes, as a former teacher, good job, well done. I was assaulted by a child student and about lost my eyesight. They too were arrested, thrown out of school, and forced to go to a reform school after he served his time. If parents don't control their kids, the courts must. All right, Holly, that's the other side of this. You know, we've got Gordon, and I feel bad what happened to Gordon. That should never happen to a teacher. I don't know if that student was 6 years old, but I think 6 years old is a big part of this story.
Absolutely. And I want to point out that teachers around the country are forced to deal with overcrowded classrooms, disruptive and unruly children. I do think that there is an issue, a social issue that we could probably talk about the rest of the evening about parents doing their job at home so that teachers can focus on their jobs at school. But I do want to point out that if a parent would have zip-tied their child, their 6-year-old child, because they were being disruptive and unruly, they would be facing criminal charges for cruelty
Holly,
to children.
that is the ultimate point. Thank you. I should have thought of that, but that is absolutely right.
I've represented people all across this state and in this country that have done way less to their children to take care of them or to discipline them, and they get arrested, and then they are having to hire an attorney. They are having to have people come in and take a comb through their parenting skills. I mean, that was the first thing that I thought when I saw this, and it disgusts me.
Yeah, try explaining that one to family services, that you're zip tying your child's hands behind their back. It's not going to work.
You'll be arrested.
You'll absolutely be arrested, and you won't have custody of your child. Yet, under the guise of law enforcement and kind of with the applause, I guess, of the folks at the school, that tells me a lot about the school administrators as well, thinking that this is the solution at this moment to this problem, not saying anything. By the way, folks, that officer is a former police officer now, no longer works for that force, but this was newly released video. Ashley writing tonight, the officer was rude. Molly, that officer had discretion as well, right?
Of course he had discretion. And also the news has reported that the Officer Turner in this case, not only arrested the 6-year-old girl that day, but later that same day made another arrest of another elementary school student. And the Orlando prosecutors had since dismissed both cases, but this was a bit of a pattern for Officer Turner. And there was even a comment captured on his body cam footage later that day where he says something like, arresting the 6-year-old is a new record for him. This is not an appropriate mentality. We have a huge issue.
Not at all.
With the school-to-prison pipeline in this country, and this is a prime example of that problem.
All right, I want to read 2 more comments quickly before I run out of time here, because I want to get both sides of this, because Rebecca writes, she may be traumatized, but she isn't physically hurt. What if a teacher had been seriously injured or knocked down or out? If there is a zero-tolerance policy, this is what parents should expect to hear. I'd expect to get a phone call. Grace is writing, at 6 years old, I think I knew enough to keep my hands to myself. She isn't a 2-year-old. Okay, so what do we do with a 4-year-old in the middle there? That's my question. 6 is young. 6 is so young. All right, Molly Palmer, Michael Sterling, Holly Waltman is like having the A-team here tonight. Molly, this is your first time You
Wow.
better come back. Awesome job. I really
you.
appreciate it. All right, folks. Thanks so much for joining us, folks. And as I leave you tonight, think about what happened to this 6-year-old, okay? She got zip-tied. She had a tantrum. You know what she needed more than anything else at that moment? More than zip ties behind her back, right? So tonight, please, before you go to sleep, don't forget to hug the kids.
This is the woman who says she saw the white Bronco at the time of the murder parked in OJ's driveway.
On the next episode of OJ 25.
The best defense in the world is an alibi.
And you just made the reservation, didn't you?
See? Yes.
Miss Lopez, we just called the airline. They don't show a reservation for you.
An all-new original true crime series, OJ 25. New episode Thursday night at 9/8 Central. Only on CourtTV.